Welcome to Between the Briefs, a podcast by Steno. We share practical tips and expert insights on the pretrial process, court reporting, and legal technology to keep you updated on how technology is revolutionizing the litigation process and the wider legal sector. I'm your host, Adrian Cea. Hello, and welcome to Between the Briefs, brought to you by Steno. I'm your host, Adrian Cea, and today we're diving into the critical role of whistleblowers in uncovering corporate misconduct and the impact of technology on legal practice. Joining us is Jason T. Brown, a seasoned attorney and former FBI special agent known for his expertise in handling complex litigation and whistleblower law. As a managing partner at Brown LLC, Jason has led his firm to remarkable success. His unique blend of legal acumen and investigative experience positions him as a pioneer in whistleblower law and corporate accountability. Today, we'll explore his insights into the recent case, the importance of whistleblower law protections, and how technology is transforming this legal landscape. Jason, welcome to the show. How are you today?
Good morning. Pleasure to be here. Thank you for having me on.
Of course. So one thing I really want to cover is your expertise in whistleblower law. For any of our audience that's listening, what exactly does that entail?
That's a very niche area of law that involves courageous individuals that have information about generally corporate malfeasance that potentially implicates something along the lines of fraud against the government, where you see widespread Medicare, Medicaid fraud. It could be that the corporation's committing tax fraud, and it could also be a securities fraud. Those are the biggest programs under whistleblower law. One thing, it's a very wide net when you talk about whistleblowing. Everybody thinks they're a whistleblower when they unearth some misconduct at the company, but there's no common law concept of enabling people to have protections under just judge-made law. In order for a whistleblower to enjoy protections under the law, there must be an actual identifiable statute that the whistleblower invokes in order to obtain those protections, which is really one track of whistleblowing and whistleblower law. And the second is something known as the QTAM, or relator provisions. And those go beyond just protecting the individual, but in fact, also the individual is able to obtain a percentage of whatever the government recovers. Medicare fraud for each year, for example, there's over 2 to 3 billion recovered. Whistleblowers are entitled to up to 30% of that if it's done through the False Claims Act. So in aggregate, each year, whistleblowers could receive up to $1 billion.
That is wild. Now, hearing this, it sounds like this kind of presents a challenge for yourself, because if whistleblowers aren't immediately enacted these protections and they need to invoke them, does that kind of pose an issue where they're less likely to come forward?
Well, I think they are likely to come forward and at least speak with counsel to understand what their rights are under the respective statutes. So they're not immediately imbued with any blanket protection for blowing the whistle. For example, if the company is supposed to put things on pink paper and it's doing it on blue paper, and they think they're going to complain to an authority and receive protections, most likely they are not going to do it. That's something against company policy. It doesn't implicate public policy. For them to enjoy protections, it has to be in an identifiable statute. But once that statute is triggered, regardless of whether or not they formally invoke it or not, they generally have some degree of protections. For example, if a defense contractor company is knowingly giving the U.S. government defective tanks in order to embolden their own profits, and they complain about it and they're retaliated against for the complaint, there are some whistleblower protections because they have complained about, number one, something that implicates federal taxpayer funds, which the False Claims Act protects under the age section of the statute. And number two, something that implicates national security and potentially the safety of our soldiers and sailors. So that's pretty important as well.
I see. Okay, so there's definitely a line here that people need to identify in terms of what exactly falls into that category of whistleblower protections. Now, I have a question for you. You have a history as a former FBI special agent. When it comes to this, how has that played a big role in your success as an attorney?
Well, I think fortunately, it's played a huge role But even before the FBI, as a little kid, I always wanted to be an FBI agent. So I was always reading detective books and how to interrogate people and things along those lines growing up. But I think it's helped on multiple levels in the extent of our law practice here, where we have approximately 25 people that are hardworking individuals aligned with the values of the whistleblowers. I think there's some degree of empathy that I have. Whistleblowing, a lot of times, is a very uncomfortable situation. You've secretly blown the whistle. The company doesn't know it, but you feel like everybody knows that you're the one that did it if there's an investigation that's triggered. And that's analogous to some of my work at the FBI, where I ran and participated in undercover activities with organized crime, where at times I wore a wire, times I transmitted, which is generally a step beyond what our whistleblowers have to do. So we have the empathy. I have the empathy from my prior career. I think it also helps in other fashions as well, particularly when we conduct depositions. In the past, when I was with the FBI, I would do interrogations. Interrogations, you're speaking with someone with a purpose, and that purpose is to potentially incriminate them. So you're having a conversation with them and trying to elicit a comment that at the end of the day may make that person go to jail for the rest of their life or receive the death penalty. Some serious stuff. In contrast to what we do in civil litigation when we conduct a deposition, it's just about money. I know people say, well, money is money. Yeah, money is money, but you're not going to jail for the rest of your life. So I think from the intensity that we did in the FBI with interrogations morphs well into the function of having to conduct effective depositions.
I see. So it's helped you understand body language, pick up on certain questions that you should be asking to get the right result.
Yeah. Adrian, you're revealing all my secrets, but yes, or some of my secrets. Detail is the enemy of the liar. So when we're conducting a deposition, there's certain information that we know is truthful and we expect the witness to lie about. Early in the deposition, technique-wise, I try to establish a baseline of the witness, and some of this does borrow off FBI and other training. And oftentimes, you'll find out during a deposition, particularly if you use a video one, it's really fun to look back. The witness, when they lie, they have certain tells that you can pick up on. It could be they say to you and the answer's yes, and all of a sudden, yes, sir. And you should think to yourself as the examiner, why did they all of a sudden give me a yes, sir? Why did they deviate from the norm? It could be from body language where they lean in or lean back when they lie, blade their body away from you when they're lying. Things along those lines you should be very attentive about as an examiner. And an enhanced feature is getting the video and retrospectively looking back, understanding the implications of the transcript about what they said and marrying up their body language to see, oh yeah, here it was. One other big thing is eye shifting. Typically, human beings, and even if they're conscious of this, when they're accessing the portion of their brain in which they need to access stored information, their eyes will shift in one direction. If they are trying to lie and accessing the creative portion in the brain, their eyes will shift in a different direction. And it's fascinating to watch. I watched it during the presidential debate, and vice presidential debate, taking any side in politics. But all of them had some pretty pronounced tells.
I can imagine. And it almost seems like you're viewing life from a different lens at that point, right? Being able to pick up on these tells. I wanted to ask you, with the rise of digital depositions and doing things over video, do you think it comes with a challenge in pointing out these tells with the person you're deposing? Is it harder, or do you find it much more convenient?
In order to maximize your chance of success of a deposition, I strongly encourage you to be in the room with the deponent. I think that adds pressure, and people are less likely to lie to you to your face repeatedly. They'll still do it, but they're less likely, and they'll feel more uncomfortable and give up more tells. In contrast, technology also has its perks. You conduct an awful lot of depositions in a short period of time for bigger cases. But I think you lose a little bit of your wow factor, particularly if you inherently have truth detection skills. Because the witness doesn't feel the pressure. They're looking into the camera, or are they? There's a menu of people they could actually be looking at. And when you stare them down, it's not the same thing as staring into somebody's eyes directly. So I think you do lose a little. but there's certain things in technology, and I'm sure in the future, you're going to even have real-time technology that's monitoring the eye gazes, monitoring all different things, and that technology may be spitting out when they think that individual is lying.
That's fascinating. Now, I wanted to ask you about going up against corporations. Sometimes when you get a whistleblower, you're facing a ginormous corporation who has, it almost seems like endless amount of funds or assets behind them to defend themselves. How do you tackle this from like a David and Goliath perspective?
Yeah, I find it quite enjoyable. I always love the challenge. Another thing growing up, my favorite detective was Columbo. For people of my generation and before, they know him. Others may not, but he would always go against the most sophisticated criminals and figure out a way to defeat them. And similarly, I think we do a terrific job of blueprinting our cases once we're involved. And there's only so much a defense firm and defendants can do to obstruct at the end of the day. I think if you take a healthy approach to litigation, which is be courteous and give comity to your adversaries, no matter how small or big, but don't take nonsense from them either. And I think one of the things that we do well is, we do accommodate our adversaries, but if they want to go into the typical D for delay from defense, we tee it up and let the court decide. And if they think they're going to paper us to death, well, I love reading, so it's not going to get past me and my team. And at the end of the day, if we earnestly believe in our client, and we do, because we generally take these cases on contingency, so we're only paid if we win, no matter what they can bring our direction, we're going to advance that case. We'll pick a jury and ultimately let the jury decide. And I love going against the best attorneys in the country because I think it brings out my A game.
Love to hear that. You got to take it full on and just be prepared to win. Now, I have a question for you. Did your time at the FBI help build the network that has helped your success as an attorney? I feel like a big part of whistleblower law has to be who you know and how you can work together towards a common goal. Has being in the FBI helped build a good network of resources?
I would say yes. In any industry, it's critical about who you know and how you know them and what sort of relationship you enjoy. The FBI, when I was there, is perceived as relatively nonpartisan. The individuals who work whistleblower cases still to this day, I perceive as nonpartisan. There's other elements of the DOJ and FBI that people may perceive otherwise. But really, a lot of this litigation is interfacing with the Department of Justice for False Claims Act case, False Claims Act whistleblower cases, the SEC for SEC whistleblower cases, the Commodities Exchange for CFTC whistleblower cases, the IRS for IRS whistleblower cases. And really, with the government is sluggish, it's hard to move things. So the fact, number one, that I was a part of the government, a product of the government to some extent, and I understand how to move things, I think helps. Also, who to direct the case to is important. If you're filing a case and you have choice of venues and you're just shooting from the outside and don't know that one of the United States attorneys in a certain district is the expert on cybersecurity initiatives, so try to steer it in front of that individual, you've already potentially won the battle by your choice of law, choice of jurisdiction, versus having it go to some jurisdiction that may be a black hole for those type of cases. And if you can pick up the phone, and not just me, but if you've developed a reputation and you have contacts and sources, and you can call up headquarters and have that level of access and find out, hey, I have a great customs fraud whistleblower case. Should I file that in New Jersey or California? And all of a sudden here, of course, you file those things in New Jersey. And those are invaluable tips. And nobody should rely on that. Although what I just said about choice of venue for customs fraud cases, it should depend upon the individual facts and circumstances of that particular case.
I see. But it could definitely play in your favor if you essentially file your case correctly and are in a more advantageous position when it comes to taking on that case.
And the government, even though they're not supposed to, even though they're supposed to treat everybody equally, who are they more inclined to want to work with if they have a very labor-intensive project where they are going to rely on the firm? There is the public-private partnership contemplated under the False Claims Act, where private law firms can do substantive work into the case, including document review and depositions. Are they going to trust somebody that they don't know, loose lips sink ships, and they're worried about at the end of the day, it may compromise the integrity of the case? Or are they going to go with a firm that has a track record that has several Department of Justice alumni like our firm does? And I'm not saying that it happens that each case, I'm sure they're doing objectively, but it's got to play some sort of role.
Of course. Now, for our listeners out there, I want to walk them through what a typical case would look like for whistleblower law. When someone comes up to you and says, hey, I do have a case here, and it turns out that they do in fact have a case, what does that process look like?
It's a comprehensive intake process where we try to understand the nature of the case, the potential value of the case. And I think that's critical, because if you're going to go stick your neck out, and you don't always have to stick your neck out, and we can talk about anonymity in a second, but you probably should know what's potentially at the other end, although there's nothing guaranteed. And then we go over comprehensively with the whistleblower what the pros are and what the cons are, how long the process may take, depending upon what program is initiated, what the potential consequences is for them at their employment, or not they should start planning for their own parachute to get the heck out of there. In some circumstances, it gets to be pretty intense, because under whistleblower law, under the False Claims Act, and even SEC and other programs, there could be a criminal element of what's going on, not just civil. So if the conduct, for example, is a kickback scheme, and the whistleblower may be profiting from the kickback scheme, they may have criminal exposure themselves. And that's something that has to go into the analysis. And if you want to work with that individual going forward, you have to explain to them, hey, someday the FBI is going to come knocking either with you or without you, and you're better off being on Club Fed when they start knocking. And you start understanding that even if we don't file the whistleblower, maybe you need to go to get a criminal attorney and blow the whistle that way, so that way you don't go to jail for the rest of your life. But there's decisions that need to be made. And I think you really need field vision, and a lot of field vision comes from experience. And there's very few firms that have sophisticated depth of experience in the whistleblower laws like ours do. So yeah, it is a process, and we are not just driven by the money at the end of the day. It's good. We enjoy it, but I'm already at retirement, well beyond what I could do to retire. I just love helping people out. So what we're driven by is trying to make the best guess about whether or not filing the case is in the best interest of the whistleblower themselves.
I see. It sounds to me like there's a large portion of this that's going to be managing your client effectively. It sounds like it could be quite a scary process, right? There could be consequences for a lot of the parties involved. Is the fear of them backing out and all this work is lost, is that something that you think about when it comes to these cases, or is it actually a fear?
Anything can happen, and often does, in any piece of litigation. So we do invest tremendous resources into these cases, and it could take years. But yeah, it could happen. But ultimately, if the individual wants to back out, we would explain to them, you can't be barely pregnant. You've already started the process, and now you have nothing but potential downside and no upside. So why not let it play out and continue? But if they have real earnest reasons why they want to back out, we would have a candid conversation with them, and we would ultimately defer to our client's wishes. Now, yeah, that could hurt them. That sometimes hurts us in terms of we may have $1 million of time, a couple $100,000 in costs in the case. Fortunately, we're big boys. We have a war chest, and our successes make up for the cases that go south for one reason or another. So ultimately, at the end of the day, we will capitulate to the will of our client, of course, after counseling them about the ups and downs of their decision.
Okay. And when you see the resolution to these cases, how have you seen companies actually transform and change from the whistleblower conclusion?
It's remarkable, because you do see some pretty sophisticated companies enact comprehensive changes as a result of the litigation that we've enacted, including installing corporate monitors to make sure the conduct doesn't repeat, better education and compliance mechanisms to make sure individuals are aware of their rights and their ability to report it to the government if they know about any of these schemes. Sometimes you see management in its entirety ousted for calcification of a scheme that they knew about and shouldn't have let persist for so long. And sometimes the federal government doesn't let them go so easy. There's a CIA, and not the CIA that people generally hear about, but a corporate integrity agreement at the end of the day, where the company is not free and clear of the litigation. They have to comply with certain terms of monitoring from the Department of Justice or the Department of Defense or whatever the regulatory agency is that's implementing it. And that really keeps the company on its toes as well.
I see. So there is effective change that is forced either by the government or by the company itself internally as an agreement or a settlement to the case.
Generally, you do see some effective change for the bigger cases. And then there's the recidivists, where no matter what you do, they're going to do it again. And the False Claims Act, just like any other statute, has a limited period of time in which it can capture damages. And they may be thinking, hey, if I get away with this for 20 years for our company, we'll make $250 million, but the statute itself only lets you go 6 years back. So it's worth it. Unfortunately, they probably make some of those decisions in boardrooms.
Wow. Wow. It's actually pretty shocking to think that this is premeditated sometimes and they know what they're doing, but they still go ahead and do this action that breaks the law.
Yeah, for corporate malfeasance, particularly when they feel emboldened. For example, if we take it slightly out of the traditional whistleblower space, and let's talk about the monopolies and the phone companies. They have arbitration clauses that everybody has to sign before they utilize their services, like AT&T, Verizon, things like that. If they knowingly overbill the consumer by 50 cents a bill, and they're going to raise each month probably $10 to $100 million just based upon the volume of customers that they have. But yet they can't easily be held accountable through private litigation because there's an arbitration clause that prohibits class killing, makes class killing. So you can't file a class action. You can only proceed individually, and who's going to file a case for $3 in arbitration? So now, thankfully, if they do make those decisions in the boardroom to consciously defraud consumers, in the past, where there has been no real mechanism for a whistleblower who has inside information to that extent, there's nothing incentivizing them to step forward. The Department of Justice this year, they unearthed a brand new initiative, the Corporate Malfeasance Program, where even though there's not a statute, if somebody comes forward with a scheme along those lines that could also be considered criminal in nature, then potentially they will receive a very big whistleblower award for blowing the whistle on something like that.
Wow. So this is the government's way of combating this essentially gridlock that corporations have created in terms of being sued. They are essentially giving any type of money or monetary reward to any whistleblower. Do you think that's actually encouraged people to come forward? Have you seen a difference?
Yes and no. For those in the know, like our firm who has a specialty practice that really focuses on whistleblower law, we know we can navigate certain cases to that program where before there was no avenue to really do anything with the information. On the other hand, unless and until they broadcast a huge success with the program, nobody really knows how it's going to play out. So yes, and we tell individuals who are going to utilize that program as well, yeah, it looks terrific, but unless and until the government actually has paid people under this program, we don't know actually how it's going to play out at the end of the day.
All right. A few last questions here for you. For anyone that is aspiring to get into law or maybe even whistleblower law, what piece of advice would you give them that you wish you knew sooner?
I think it's critical to have some sort of vision about what you ultimately want to do in life and work a job that aligns with your values. You don't want to go to work each day miserable. And if you're doing it, then just don't do it. Just quit. That's not a life that you should have to endure. But I think early on, if you have the opportunity, you should try to intern at different law firms, particularly programs like Brown LLC, where we train people how to be lawyers, even when they're not lawyers, if they're interested in the profession. So if they have an administrative position here at the firm, we may do deposition prep. We may do debate. We may do oral argument. We may just talk about settlement strategies so that you can get a really taste and flavor for how the profession is. And there's certain environments, part two of that is you may want to try more than one environment. One of my first law firms I worked at was just nasty. I haven't been at a few firms. I've generally stayed wherever I've been my entire career. But when I was in law school, I showed up at a firm. They were just all yelling at each other. People were crying. Well, the partner told me, sit. And he threw a piece of paper back at me.
Gosh.
Yeah. So I was like, this is not for me. I said, I don't need to take your garbage. I want to become a successful lawyer. You don't have a right to yell at me. Just like me as head of the firm, I don't have a right to yell at anybody at my firm. So I think you really need to expose yourself to the different work environments, try to intern and get clarity about who you are and what you want to do in life, and try to obtain a job that really is consonant with your own values.
All right. That's a great piece of advice. Now, Jason, when it comes to the industry, what is your hottest or spiciest take on the industry? This could be something controversial, something you've learned. What is your hottest take?
Just that there's no end to the industriousness of the fraud that goes on from the bad guys. And we bring balance to the force. In order for entities and individuals to be held accountable, good people have to have courage to come forth to report that information in the right manner, to hold them accountable, because otherwise the government's going to get bled dry. People's taxes are going to go up. People's quality of healthcare is going to go down. But for the fact that good people are going to do the right thing at the right time.
All right. Well, that's a great take. Jason, thank you so much for joining us here today. It's been a pleasure interviewing you. Do you have any last remarks for the audience?
No, just it was a pleasure speaking with you. Thank you very much. Of course, I'll promote my firm slightly if that's permissible. Brown LLC, our website's ifightforyourrights.com. We just had some remarkable achievements, as we do every year, and we look forward to giving free confidential consultations to whistleblowers.
All right. You heard it here first. I hope everyone that's listening enjoyed this conversation, and we will catch you on the next one. See you later. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.